We have already covered all the definitions of criminal procedure code. Today now let's take up the differences between cognizable and non-cognizable offenses. Whenever you begin a topic, always take up the definition first. So to begin with the differences between the two, let's start with their definitions. The cognizable offense is given in subsection C of section 2 of criminal procedure code, whereas the non-cognizable offenses are given in subsection L of section 2 of criminal procedure code. In my previous video lecture, I have already explained all the definitions of the criminal procedure code. वहाँ पे हमने एक ट्रिक अपनाई थी कि कॉग्निजेबल एंड नॉन कॉग्निजेबल ऑफेंसेस किस सबसेक्शन ऑफ सेक्शन 2 में आते हैं. तो हमने याद किया था कि CL कैजुअल लीव विच इज़ गिवन इन ऑफिसेज, एंड इफ़ यू डोंट रिमेंबर दैट CL आप याद कर लीजिए और उसको याद हो जाएगा कि कौन से सेक्शन 2 के कौन से सबसेक्शन में कॉग्निजेबल एंड नॉन कॉग्निजेबल ऑफेंसेस आते हैं. टू बिगिन विद द डिफरेंसेस बिटवीन द टू, द कॉग्निजेबल ऑफेंसेस एज गिवन इन सबसेक्शन C of section 2 says that it defines cognizable offenses. Cognizable offenses or cases means a case in which a police officer may arrest without warrant as per first schedule of the Criminal Procedure Code 1973 or under any other law for the time being in force. Whereas the non-cognizable offenses as defined in subsection L of section 2 of Criminal Procedure Code, non-cognizable offenses means an offense for which and non-cognizable case means a case in which a police officer without any warrant has no authority to arrest. In simple language, the difference between the two is, as per the definition, cognizable offenses or the cases the police can arrest without a warrant as given in the first schedule of Criminal Procedure Code 1973 or any other law for the time being. Whereas in non-cognizable offenses, it has been, as per the definition of it says the police cannot arrest without a warrant. Coming up with the second difference between the two, cognizable offenses are serious offenses, whereas the non-cognizable offenses are trivial offenses, matlab chote mote, minor offenses. What are you going to write under it? You're going to write that cognizable offenses are usually offenses which are serious in nature, that is, heinous crimes. For example, waging or attempting to wage war or abetting the waging of war against the government of India. Murder, rape, dowry death, kidnapping, theft, criminal breach of trust, unnatural offenses. These are all covered under serious offenses and cognizable offenses. Non-cognizable offenses are trivial offenses. What are you going to write under it? Non-cognizable offenses are not much serious in nature. For example, assault, cheating, forgery. Difference number 3, arrest. In cognizable offenses, a police officer may arrest without warrant as per the first schedule of the Cr.P.C. 1973 or under any other law for the time being in force. If you remember, this is also given in the definitions of the cognizable offenses. And arrest as per the non-cognizable offenses, a police officer has no authority to arrest without warrant. This is a big difference. You have to remember this always. Fourth difference between the two, FIR. In cognizable offenses, FIR can be registered without magistrate permission. Whereas in non-cognizable offenses, FIR cannot be registered without the magistrate permission. The fifth difference between the two, investigation. In cognizable offenses, a police officer is under legal duty to investigate without any orders or direction from the judicial magistrate. Whereas in non-cognizable offenses, a police officer has neither the duty nor the power to investigate into such offenses without the authority given by the judicial magistrate. Means the judicial magistrate will order the investigation in non-cognizable offenses. The sixth difference between the two is cognizable offenses are public wrong, whereas non-cognizable offenses are private wrong. Cognizable offences are considered public wrongs, and therefore the prosecution of the offender is left to the initiative and efforts of the state. Non-cognizable offences are considered private wrongs, and therefore the prosecution of the offender is left to the initiative and efforts of a private citizens. So whenever you see if it is given Kedarnath versus state of Punjab or state of Rajasthan, you can recognize that it is a case under a cognizable offences, and wherever there is a case between two persons, that is Mr. A versus Mr. B, that is going to be a non-cognizable offences, a private wrong. Now let's come to the seventh difference between the two: punishments. In cognizable offences, punishment may be given for imprisonment for 3 years or more, whereas the non-cognizable offences are punishable with imprisonment for less than 3 years or fine. With this, we come to the end of the differences between the cognizable and non-cognizable offences, but don't forget to sharpen your skills by going through the following question and answers.
you